Justice Sotomayor?
You're asking us on Section 11 to reverse the judgment below. But respondent is asking us to vacate and remand so that they can have an opportunity to prove tracing. You're basically arguing, I think, that they waive that. Isn't waiver always an issue that we let the court below decide?
I don't know that you always let I mean, it's a question of forfeiture here, not only in the courts below, but also in this court. They didn't raise in their brief in opposition any claim that, oh, by the way.
Well, I think they do when they say vacate and remand and let us do it.
But Your Honor, normally this court doesn't reach issues or take account of issues that were forfeited even in this court. Again, we said in our petition.
But it wasn't forfeited in this court. They said, give us a chance to prove we can.
Under Rule 15, Your Honor, they forfeited it by not saying.
I'm not going to fight any longer with you on that. I was intrigued by some amici suggesting that we adopt a burden-shifting framework. As I understand that what's happening here is that these direct listing mechanisms are being touted and advanced in order to avoid having any tracing of direct listings of public offerings. And so if we were concerned about that, it did seem to me that the burden-shifting idea made some sense. You are purposely avoiding a public offering to avoid having to sell only registered stock during a locked-up period. And so you're evading all Section 11 liability, even though you are registering, as the SEC requires, you're issuing a registration statement before you can issue any stock whatsoever. So I guess my question to you is, shouldn't we be leaving open that question? On the burden shifting, and why shouldn't we?
So, several responses. The burden-shifting argument is one of the many issues that wasn't raised in the brief in opposition or below and shouldn't be addressed by the court. Number two, burden-shifting.
I'll accept that, but should we leave it open?
Well, I don't think the court should address it at all because it's not presented in the case. But if the court were to say something about it, there's no basis at all for burden-shifting in this statute.
Well, there's no basis in the statute for tracing either.
But the statute
judicially.
Well, again, as I said, Section 12A1 shows that Congress necessarily mandated tracing. But beyond that, the statute in Sections 11 and 12, Congress very carefully addressed the question of burdens. It specifically assigned certain burdens that would normally have been on the plaintiff to the defendant in both of those provisions, such as the burden of proving a lack of negligence or due diligence. And so Congress has spoken very specifically to the question of burden allocations, and this Court should not essentially redo Congress's work for it and decide that additional burdens should be placed on the plaintiffs.